Welcome, everyone. My name is Christiana Morales. This is SDP Connect. We have a great presentation for you today. We have some guests, which you're going to be very excited to see. Before we get started, we want to have a couple announcements. So I want to introduce Judy Mark, our president, and she's going to do some announcements.
Hi, everybody. Great to see you. I see so many people I love in my little frame. Hi, Connie. Hi, Carvey. Hi, Tommy. It's so wonderful to see you all. I wanted to let folks know about the master plan on developmental services. So some of you may have heard about it, but if not, I'll explain it in 1 minute or less. The Master Plan on Developmental Services is an effort by the Secretary of Health and Human Services, Dr. Mark Galley, to think about the developmental service system in a holistic way, to break down the silos between the different systems that are supposed to support people with developmental disabilities, such as IHSS, Medi-Cal, regional centers, educators, all those different systems, Department of Social Services, that we're trying to create a seamless system that helps everybody regardless of which system you need to get your services from. And there is a committee that has been established and appointed by the secretary that is very diverse. From people from all different parts of the system, from self-advocates to family members to service providers to regional center directors, as well as people from other systems, from the aging system and from other organizations like the Center for Independent Living Centers, are on this master plan. And they are, the committee is now being broken up into 5 working groups in various areas. I would love if you have those. Do you have the link? So for that work group, thank you for doing that. For that work group, you will see they have created 5 different work groups. And when you click on work groups, not much happens. But there is an online application. Let me get you the link for the direct online application and put it in. Thank you, Christiana. Can you click on where it says online application too? Thanks.
What we'll do on mine, because I actually already applied, it's just going to say that I've already applied. So if
so I can do it. Let me share because I have not applied. Hold on, let me get it up here. Yes, this is right. Okay, so you'll see this is the work group application. It's a pretty simple application. The hardest part, honestly, is they make you write a short description of your background, explaining why you want to serve on a work group and your skills, experiences, perspectives, and you cannot exceed 100 words. So that is the hardest thing about it, because that's a lot to get into only 100 words. But these are the 5 work groups that are going to be forming. This group 1 is really about creating a system that people trust, that is person-centered. So we're looking at the way that the regional centers interact with us and the way that other systems also interact with us. The second group is about the breaking down of those silos that I talked about between the different systems to ensure that people can get access to services, the right services for them when they need them. Group 3 is about the actual workforce. So these are the people who are providing the direct services, how to keep them trained, keep them stable so that they don't leave on a regular basis, and make sure that they are person-centered. Group 4 is really all about the transparency and accountability of these systems, and to ensure that they are tied to outcomes that matter to us. And so that's going to be looking at the consistency across regional centers, the consistency, and then how to tie sort of people's personally designed outcomes to service providers and other kinds of and regional centers. And then the last one is kind of, it's named and it's not obvious what it's about. It says individuals are entitled to lifelong services with adequate resources. And this is really focusing on, number one, the entitlement to services that the Land Term Act provides, and ensuring that that entitlement remains forever, as well as the federal funding and the state funding that we get for the services that we need remain stable and actually increase over time. And that includes the federal funding that matches the state funding. And so they're going to be looking at actually really mundane things like the waivers and the kinds of way we do federal funding. It's probably the most technical of the 5 work groups. So this is the application. We can tell you that at DVU, our primary goal is to ensure that what the outcomes of the master plan are centered in self-determination. Self-determination both in the program and self-determination with the lower s and the lowercase d, in that people are in charge of their own lives, they have choice and control over their lives. And so we want those of you who come to us at our SDP Connects, if you are interested and would consider joining one of these work groups, we encourage you to apply. It is unclear how many people they're going to accept. They were talking about 10 people in a work group, but they've appointed already 8 of the people in most of the work groups. So that makes no sense to me. And we're pushing to make these work groups much larger so that we have much more participation from the community. It is a big time commitment. You are going to be asked to go to monthly work group meetings for 2 to 3 hours every single month. So if you are going to apply, you should really make sure you can make that kind of time commitment. So I think that's it for me. And our self-determination bill just passed through another committee yesterday. It passed through the Assembly Human Services Committee, and it will now head to the Assembly Appropriations Committee. And keep the fingers crossed that by the end of August, it will be heading to the desk of the governor. So we'll keep you informed.
That's so
Thanks.
exciting. I get so excited when I hear that. I have one more quick announcement. I'm going to share my screen. So for the Regional Center of Orange County, we are doing a 3-part person-centered planning series. The third one is going to be on June 15th, and it is in Spanish. But if you would like, you can attend. We do have Spanish to English interpretation. We will put the link in the chat if you're interested in attending. It's on Zoom, and it's from 11 to 12:30 on this Saturday. So please come and join us. Okay, so what we're here to actually talk about today, the big the discussion is for the 3 models. So we're hearing so many questions about the FMS models, the financial management service models. So I'm going to do a quick review of what the 3 models are, and then we're going to talk a little bit more about specifically the difference between co-employer and sole employer. So let me share my screen again. So we have 3 models that you can select when you choose a financial management service. You can choose bill payer, co-employer, or sole employer. Now, just so you know, not every financial management service offers all 3 of them. So as you're working on deciding which financial management service to go with, you'll kind of have to know which model you want to have, so you'll know if it's available to you. Bill payer is the easiest one for me to explain, so we're going to do that one quickly and first. Bill payer means you are not hiring any employees yourself. So it doesn't mean you won't have people coming to work for you, but you're hiring a business or an agency that hires those people. So you are only using those. You're not going to hire anybody individually, but you don't have to use vendored services. So this is the key to self-determination. So you can use a vendored service from your current regional center if they're willing to work with your financial management service. You could use a vendored service from any other regional center, or you can go out and do the self-determination way and use any agency that's going to work for you. The financial management service will also pay for the goods and services. So that's really the simplest one. If you know you're not going to be hiring employees, that's the one you would start with. Okay. The next one is the co-employer model. That means you are hiring employees, but the financial management service is really going to be hiring them on your behalf. And that means is they're called the employer of record. So that financial management service will hire the people that you pick. Don't worry, we're going to go into a lot more detail about this, but that's the top level of where we're at here. Sole employer, you hire your employees. The participant is the employer of record or somebody that they choose. And don't worry, I'm going to explain what employer of record means a little bit in a second, because I know it's kind of an odd term, not something that everybody uses, employer of record. So let's start with the importance of self-determination program. And that is, it's self-determination. You get to choose your employees. So you're going to choose who you're going to hire. That means not only are you going to choose them, but you are going to be sending out the uh, advertisements. You're going to interview them. You're going to pick who you want to hire. In co-employer, you're going to do that. You're going to decide who to hire, if you're going to let them go. However, as co-employers, they do have a say in it, and there could be somebody that you want to hire that they say, no, we will not. We're not going to accept them. We don't want to hire them. In sole employer, because you, the participant, is the employer of record, you can choose who you want to hire and if you want to let them go. Now, that employer of record, that key piece, that's what we were talking about. What that means is whose FEIN, whose taxpayer number is this person being hired under? So in co-employer model, it's the financial management service. They are the ones who it's going to be under their taxes. They're hiring them. They become employees of that financial management service. In sole employer, it is under the participant, or it could be somebody that they select. So you want, it could be a parent or a loved one or somebody else if they select them to be the employer of record. And it is under their taxpayer number that they are hired. You don't have to worry about going out to get that taxpayer number in either co or sole employer. That is something the financial management service will do for you. I know as a parent, I was thinking, how do I get that? That was one of the things that freaked me out. Let's talk about background checks. So in co-employer, the financial management service decides who has background checks. Now, you have to have a background check if the person is providing personal care. So anybody who provides personal care has to have a background check. And what I mean by personal care is anything where they are touching your body or caring for you, anything like that. So those people, everybody has to have a background check. But if they aren't providing personal care, you have a choice. But I will tell you that every single financial management service in co-employer that I know of requires everybody to do a background check regardless. So this is another one of those instances that in sole employer, you have a little bit more freedom. You can make that choice. For me personally, if I hire my son's friend who we've known since he was in diapers, I 100% trust this person. I'm not going to do a background check on him. If he doesn't do personal care, I don't need to do it. If I hire somebody off of Indeed, I'm going to do a background check. So it really does get down to, you have that choice. Then we talk about the benefits piece. Under co-employer, remember the financial management service is hiring them. They are that financial management services employee. That means anything that their employees receive, your employees will receive. So if they have any benefits, they have days off, they have health insurance, all of those things, your employees will get those same ones. In the sole employer, you can decide. This becomes a little bit more important when we're talking about health insurance. In a moment, we're going to talk about why having that flexibility to decide is important. So I'm going to talk about employer burden first, then we'll talk about the health insurance. So many of you know that a directive came out in April talking about the employer burden rate. If you are in self-determination, you may be familiar with what it is. If you are not, everybody who works, who pays taxes, and they work for another person, their employer pays part of the taxes and the employee pays part of the taxes. So that employer burden rate is the part that the employer has to pay. And so, as employers in both co and sole, you are going to have to pay your portion of taxes for your employee. And that's what these are. Now, there is no federal regulation of what an employer burden, what can go into employer burden rate. Each of the states have kind of had to define it. And so the April 2024 directive was DDS defining what can and cannot go into this employer burden rate. They listed these things, the income taxes, federal income tax, the FICA. I had to look up what it actually stood for. Federal Insurance Contributions Act. I didn't know that's what FICA stood for. That's your federal Social Security taxes, those kind of things. Your unemployment tax, your FUTA, your federal. Then you have state unemployment tax. California has something called the employment training tax. And then it needs to include workers' compensation insurance. In California, you have to have workers' comp insurance. In fact, I think every state you have to have workers' comp insurance. And then we also have a required sick leave payment. And that went up January 1st. It increased that everybody that works receives 40 hours of sick leave per year. Now, different employers can choose whether you get that employee gets it all up front or whether they earn it over time incrementally. So it could be different between different financial management services of how they get that sick leave time. And that's something you might want to ask. Now, other things that could be included in it, according to this directive, is health insurance and retirement benefits. So let's talk about that workers' comp piece. What we have been told is that workers' comp and employer liability are the same thing in California. It covers both. But let me explain a little bit because I had to figure this out. I did not know the difference between workers' comp and liability insurance. Both cover workplace injuries, but the workers' comp is really protecting the employee. So if they get injured or they get sick because of their job, there's no allegation of fault or anything. They got injured. They would utilize their workers' comp insurance. It can cover things like medical bills and lost wages. So anything around those pieces. Now, liability insurance protects the employer. This is an instance where they are saying you were negligent, that they want punitive damages for this. So these are claims where they're saying there was property damage. They even can claim advertising injury. So it's two different types of things in there. So that's what we're talking about when we're talking about workers' comp and liability. Now let's talk about that health insurance piece. So in co-employer, as we said, because they are hired by that financial management service, whatever their benefits, whatever their rules around health insurance would apply to your employees. So if they offer health insurance to their employees, they would have to offer it to your employees. Let's say you had an employee, you were co-employer, they got to the point where they qualified for the health insurance. You, as the employee, cannot have any say in which policy they choose, what the policy looks like, anything like that. They'll just tell you this is how much the health insurance is, and you need to include that in your spending plan. You don't have a choice. You have to have that in your spending plan. In sole employer, because in California, you're only required to provide health insurance if you have over 50 employees. I don't know of anybody in self-determination program who has more than 50 employees. So which means you have the choice to offer health insurance or not. And so that gives you a lot more flexibility, right? If we're trying to figure out if it's going to fit within our spending plan, um, then you can work with your employee. Let's say you say, "Ah, I love my employee. They're great. I want to offer them health insurance. We're going to be able to keep them." You can sit down together, figure out the policy that's going to work within both of your budgets, and you can agree to that amount. And typically, how I see it done with almost every FMS is it's done through reimbursement. So your employee would be paid back whatever they are paying out for their health insurance. But back to sole employer, you have more flexibility. Here is a massive chart of all those things. You can download all these slides, so you will have this chart. And I want to point out there are a couple other things in sole employer that you also have a benefit to. One of them is you can hire an employee from multiple clients. And let me explain what this means is because the financial management service is hiring this employee, and because there could be issues with overtime, they often will not permit those employees to work for multiple clients. So let's say you had two kids at home who were both in the self-determination program. They were both co-employer with the same FMS. They couldn't share an employee. If they had an employee that they liked, they would have to either be at different financial management services or you would have to be in sole employer. So think about it. If they work for a financial management service, then they work for 6 hours with you, and then they go and they work for somebody else for 6 hours, who pays that overtime? And that's why there is this issue with working for multiple clients. So if you're in a situation where you have siblings or you have roommates and you want to kind of share employees, then you want to think about the sole employer model. Um, the other one that we hear often as the kind of deciding factor is some of the financial management services do not permit their employees to provide nursing care or medicine management. But in sole employer, you can hire people to do that. So that's another piece to think about. So um, I know that was a lot. I gave you a lot very quickly. Um, but I want you to know that the directive that came out, the intent was to define the what the employer burden rate is and to give a bit more transparency. And so what we know is that by May 31st, the financial management services had this chart that they needed to send to their vendoring regional center, and it laid out are the parts of our employer burden. And by June 30th, those regional centers have to send it over to DDS, the Department of Developmental Services, and they are going to approve them. And once they are approved, they will send it back to the financial management services, and they will send that approval out to all of you. So you will see exactly what is included in their employer burden rate. And they are going to post it to the Department of Developmental Services website. So again, that'll make it easier when if you're brand new and you're starting to look for them. So about the same time that this directive came out, we also had two financial management services who began moving towards sole employer. And so we invited them here so they could talk to you about um, uh, this transition for them. One is Jason Bergquist. He's from Mains'l. Hi, Jason. Give us a wave there.
Hi,
And
everyone.
hello. And the other one is Tony Venzor, and he is from Seqouia. Welcome.
Hello, everyone. Good evening.
Thank you both so much for coming and talking to us about this change. So I want to ask both of you, probably the question a lot of people have is, why are you moving towards sole employer?
Yeah, I'll go first. So, Sequoia, so again, Tony Venzor, I'm the regional operations director for Sequoia, but then also for other companies that our parent company Assurance SD owns. So I'm in a few different markets, but I've been taking over the management of Sequoia specifically in California. We are, although we're one of the newer FMSs in California, we have been in the FMS business for over 25 years in 15 different states, providing services through all kinds of different programs and payer sources and Medicaid and everybody that pays for our services. However, in all of these states and all of our business and experience, we've never actually provided a co-employer type of model. So the management from before me, so we had a manager of the office, we had a COO of the company. They made the determination that when they were talking to the regional centers and figuring out the biggest need, the regional centers all said co-employer. They said, we have tons of participants who can't get into other FMSs with co-employer. This is where we really need your help. Yes, we have sole employer. Yes, we have bill payer, but co-employer is really where most of the participants are. So although we did not have the experience behind us, they made the decision to jump in head first and try out co-employer and basically just put the program together as quickly as possible. And really, I mean, obviously we had the best intentions of helping people as fast as we could to the majority of people that needed it. We quickly realized that we weren't set up to be the employer of record. We've never done it. Like I said, in none of our programs and offices and companies that we even own in FMS, we didn't have anything put together as far as policies and regulations and just tools that we needed to be an employer in California, especially a larger employer. You know, as Christiana, you know, mentioned the health insurance. You know, if you have 50 plus employees, you got to do different things. So when the management left, they're no longer with the company. It was my job to really look at our services and look at our programs and dissect everything that we're doing. You know, from the forms to our website to everything we put together to make this program possible in California. And after going to leadership and having multiple meetings and discussions, we just came to the determination that we are not ready to be a co-employer in California. We're just not equipped to handle everything that comes with it. And we know that we can do a much better job and provide a better service with sole employer and bill payer, because that's what we do. That's our bread and butter. That's our specialty. That's what we've been doing for, you know, multiple years, and we know how to do it. So we did make that decision, and it definitely was a shock to not only myself, but all of our participants, employees, employers, and families. And since then, so for the last, I guess, month and a half, we've been just working as quickly and as much as possible to make the transition as easy as we can. And we wanted to make that decision now when we're smaller. Like I said, you know, one of the newer FMSs, and we don't have hundreds and hundreds of participants that this will affect. So that's really why we made that decision and came to that determination.
Thank you. Thanks for explaining it. Jason, why did Mains'l?
Ours is a little bit of a similar reason to Tony's and some different. We stopped enrolling new co-employer participants at the beginning of this year. We had already decided we weren't going to accept anyone new into the co-employer model, and so we haven't been enrolling anyone new since January, with the intention that probably eventually we would stop offering the co-employer model. Like Tony said, we operate in other states as well, and California is the only state that we operate as co-employer. We previously had done co-employer in other states, and those states all moved away from even having co-employer as an option. So sole employer is the option is the only option in the states that we work in right now. So we're good at it. We know how to do it. We do know how to do co-employer as well, but it splits our focus a little bit when we're trying to do two different models of employment and manage both of those. And because sole employer is really the national model, that's the one we chose to stick with. As well as there certainly are a lot more complications for an FMS doing co-employer, to be honest. I mean, as the employer of record, like the legal employer, we have employees out there working for our company, but we're not supervising them. We don't have control over their work environment and what happens during their work, and that can be a problem. And so it made a lot of sense to, if we're going to pick a model, sole employer is the one that we chose to stick with.
So I know the timing was, ironic, I guess, that it kind of came out that you were both moving towards sole employer about the same time that the directive did. So I think that some people thought that because of the directive coming out and defying that employer burden rate was why you guys had made this decision. Did that directive have anything to do with the decision that you?
It did not for us at Mains'l. As like I said, we decided back last year that we weren't going to enroll anyone new in co-employer this year. The timing just is coincidental for us. It had nothing to do with it. We really made the decision before that directive even came out. I mean, not totally made the decision, but had been going toward that plan.
The exact same for us. I had no idea that that was actually happening until it happened, and that was after we made the decision as well to make the switch.
Yeah, it's we don't always know when the directives are coming out, do we? They're a little surprise for everybody. Um, so for each of you, when do the participants need to be transitioned?
So for us, we started the process. We sent emails to everybody, every employer, all employees now, and the transition is already happening. It has to be completed and done by June 30th. That's the last day we can have any co-employer, employee, or employer or participant on our service. As of 7/1, all of our participants need to be sole employer or bill payer.
We have a longer time frame. We're just starting the transition now, and because we've been around longer, we have more participants that are using the co-employer model, and so we're asking people to let us know by the end of this month if they want to switch to sole employer with us, or if they really are convinced they want co-employer, that they're going to choose a different FMS, which is okay. And then we're going to start switching people in stages by regional center. So once people who are with Mains'l have chosen what they're going to do, we're going to reach out and say, okay, this is the month we're transitioning people from your regional center, and we'll start that process. And that will be over the next several months, really through the end of the year. So it's a longer process for us.
So by regional, so that's good to know. So what do they need to do? What do your current participants who are co-employer need to do in order for that transition to happen?
Yeah, great question. So because we're in the middle of it and we're, getting hopefully to the end of it here soon, there's a few things. So the first thing to do is paperwork. So I sent out new packets, condensed versions of our original packets, much cleaner, easier to follow kind of packets with guides to exactly how to fill out this paperwork, because the employer participant packet does have a couple of new IRS forms that most people have never seen before. So I wanted to make it as easy as possible to complete these packets and this paperwork. But basically, it's 3 pages for an employer to complete, a memorandum of understanding that they're going to be the employer, and then 2 IRS forms. So one is the SS4 form, being the application for the EIN that you were mentioning. It gives us the ability to obtain their EIN for them. So we need that completed, so that we can get that number for them. And then the 2678 form 2678 is another IRS form that needs to be completed so that we as the FMS can pay their employer taxes for them. So they do not have to worry about paying those taxes at the end of the year. I've had a lot of families say, oh, what's my responsibility to pay taxes? What do I have to do now? You don't have to do anything. We are still the FMS. We still do all that for you. So that's the first thing that we're doing is the packet. The next thing is the employee packet. So now all the employees technically have to be terminated from Seqouia because we are their employer, and they have to be rehired for their new employer. So this new packet is, again, a condensed version, but really we just need all the pages signed that have the new employer name on it. So it's basically everything they've already done. They've already done all this paperwork and packets. We just need a new signature because now we're changing the employer. But we do need employee packets for every employee that's going to work for an employer. And like you were mentioning, if an employee is going to work for multiple employers, we need a new packet for each person that they're working for to make it official and technically working for those employers. So the employer packet, employee packet, And then the regional center, we have to partner to get new spending plans and new authorizations. So the spending plan is a little tricky, and Mains'l might be doing it completely different because they have so many more people, and by regional centers a great idea. But for us, we're doing it all together. And basically what happens is, if let's say your spending plan goes from January to January, right? Well, you've been using services this entire year and you're using services through June 30th. Well, we need your spending plan to be split into two spending plans. One ending June 30th as a co-employer model, showing all the expenses you've done from January to June, to the end of June, and then a new spending plan starting July 1st through January of 25 or December, whenever it ends, showing what's left over of your budget. So you're not getting any more money, you're not losing money, but you just have to show the difference in what you've already spent to June 30th and what you're going to have starting July 1st in the sole employer model. So that spending plan does get a little tricky with the regional center, and they have to approve it and sign it and make it official. And then that will generate the last step, which is the authorization. It's the final piece that we need to say for the regional center to say, okay, you're good to go. You will get paid for your services. But those are the 4 steps: the employer packet, employee packet, revised spending plan, and revised authorization.
Jason and
Tony did a great job of saying a lot of stuff that I don't have to repeat, but because our process is very similar. I mean, there's the same things that need to be done. The employer has to fill out forms to become an employer, the same things that Tony said. The employees are going to have to fill out new forms because they're going to be hired on by a new employer. We're hoping there won't be as much changes to spending plans, crossing our fingers, because we're also going to have to be doing that employer burden adjustment that Christiana had talked about at the same time. However, that amount is going down for people from co-employer to sole employer, from what our co-employer is now. So you can revise your spending plan, but you're going to have extra money, so it's not going to stop us from being able to implement your current spending plan. But the regional center still is going to need to do new authorizations for us, especially for our fee, to switch it from the co-employer fee to the sole employer fee. Even though those amounts are exactly the same, it has to be set up in their system, right? So we're billing the right fee structure. And then, like I said, with the paperwork, no one needs to do that right now for Mains'l, because we're going to reach out to you when it's time to switch, because we're doing it over a longer period of time. So that, and we'll do as much of that paperwork as we can through DocuSign, so we can streamline the process, get it back easier and quicker as much as we can.
good. So I think kind of the big question for a lot of people is, what is their, on a day-to-day basis, if you were in co-employer now, when they switch to sole employer, is it going to be different for them?
Yeah, so that's the number one question that I've been talking to dozens of families about, and what do I need to do? What's my new responsibility? I don't want to do this because I've never done it and I don't know how to do it. And what I've been happily telling people is that you will notice no difference whatsoever. Employer, employee gets paid the exact same, submits timesheets the exact same, EVV, vendors will not notice a difference. Vendors get paid the exact same, submit invoices the exact same way. Everything will be working exactly the same for Seqouia. I can't speak to any other FMS. I don't know how any other FMS does it or treats sole employer differently from the co-employer. With Seqouia, it's the exact same, and there will be no noticeable difference that they'll see. Obviously, in the background, we're paying taxes differently. The employer, is the EINs, and we do all that and behind the scenes so that they don't have to worry about any of that. But yeah, virtually no difference between the two models for us for services.
And when we talked about that transition, the one thing we didn't ask about was that workers' comp. So, and when they move from your co-employer to the sole employer, will they stay with your workers' comp?
So again, this is another thing that only I can speak for Seqouia. We do cover workers' comp. They do not have to worry about buying a workers' comp policy, a workers' comp on their own, anything like that. They are still covered with our umbrella workers' comp policy, co-employer or sole employer. They don't have to worry about it.
Okay. Jason, same question.
Yeah, well, I'll start with that part. We are the same. People using the sole employer model with Mains'l don't have to go find their own workers' comp policy. They will still be able to use our same policy, so that will not be a change. I know that's a big question that people have. And then the rest of the question is the same as Tony. Day to day, you shouldn't see any difference. You still choose your employees, you still hire them. The paperwork you fill out is almost exactly the same with the employees. You'll choose whether you want them to have a background check or not now. But otherwise, that paperwork will be the same. And then they still have to do their timesheets the same. You still will approve their timesheets the same. Day to day, you won't see any difference in how the program operates at Mains'l.
So, I guess the last question is, if people have questions or concerns, who do they reach out to at each of your?
Yeah. So I can copy and paste here a few email addresses that people can either call us at the office, number one. Number two, we have an office email that goes to everybody that is kind of general, just for everything, catch all. And then we have 3 email addresses that people can use an email. That's one being myself. And then we have Magdalena in our office. She deals more with the employees and setting them up. And then we have Jonathan in our office, who deals more with the vendors and budgets and spending plans and answering questions with those. So all 3 of us will be able to help anybody with questions.
I will put information in the chat too. We have an email address that information went out to all of our families with. So it's the same email address that people can send questions to. They can certainly talk to their Mains'l contact, but we're also hoping to get all those questions into our more general mailbox, because we're also having 2 webinars kind of similar to this to answer people's questions. And so if we get those into our general, then we can make sure to answer those during the webinar. If we have those questions ready ahead of time, people will be able to ask then, at the webinar too. But if we have them ahead of time, especially if we can see, well, a lot of people have this question, we can also prepare our team to be able to answer those questions too, if we see a lot of people asking the same questions. So I'll put that email address in here as well.
Oh, perfect. And when you do have your webinar, if you want us to share, we can share it too. If you send it to me, I'll make sure that everybody knows about it. There was a question in the chat that I think is so relevant to both of you. I want to jump ahead and ask this. It's from Elena Tiffany, one of our DVU wonderful people. And she asked, are there any tax implications for sole employer? Because there was the concern that if she messed up any kind of income benefits, because in sole employer, this is going to be in her name. And I thought that's a great question. Jason, do you want to go first, since we've been making Tony go first?
I'm happy to go first. Yes, the short answer is no, there's not tax implications. What happens is one of the forms that you fill out it's an SS4 form for the IRS, and it sets up that tax ID number, that EIN number in your name that makes it totally separate from your personal income taxes, your personal income. It totally separates it out. It's still attached to you, but it's not attached to your personal taxes. And so then it's really meant so that it doesn't mess with your taxes. And then everything we're filing for employment taxes, when your employees get paid and things like that, are just totally kept separate. And then we're not messing with your stuff and you're not messing with our stuff. That's our responsibility. It's a really good question. That's one that a lot of people ask.
Yeah, great question. And then I did have Sarita Ruiz at 4:59 had asked if Tony can put his business info in the chat, and he said he was already going to do that. So I just want to make sure actually both of you could do that. That would be great. Yeah, actually we had a few people asking for your info, so we got them covered. Are we ready to go to questions? So with DVU, what we do is we gather all the questions from the chat. I will read them out, and we alternate with people who raise their hand. And so, Jordan, how are you doing? Go ahead and unmute.
Thank you very much for having this. This is very important. I wish I would have gone to a meeting like this 3 years ago when I came into SDP. My question is on the legality of it. We all know that California is a litigation-riddled society, whether frivolous or non-frivolous lawsuits. And maybe you're a client lucky enough to have a trust, coming up from a parent, there are a lot of parents that I met and talked with and families say, because I'm a client, I'm also on the SDP Self-Termination Advisory Board, been doing it for quite a few years. And I've talked to parents and clients who say, hey, we have a trust coming up, or we have money, or some clients have a huge budget. Maybe they have a really big, over $200,000 budget. So my question is, I understand in one sense, because I've talked to people who say that one of the reasons that the FMS is going from code to SOL is because if a client, as I believe Jason mentioned, we're not there day-to-day, so we don't see what happens. If a vendor decides to sue a client for whatever reason, whether it's fact or fiction, the FMS can sort of wash their hands of the whole thing, say, we're not the employer record, so don't call us, call your client, he's your client, we'll call him Jordan, is the employer of record, so hey, deal with him, sue him. So where are the protections in both cases? Because I know the FMSs obviously don't want to get sued and they don't want to have to, go to a labor court, settle out a labor court. They don't want that. Where does the responsibility of a client, if a lawsuit was to come about, now you're the employer of record, potentially have the potential to get sued. Maybe they'll want to come after your own monies, if you have any, or your regional center money. Is there any protection in place for that? Especially again in California, where we have a lot of lawsuits and people may find out, hey, your family's wealthy, you live in a nice place, your family set something up, we're gonna go after you for whatever reason, true or not. Now you're the employer of record, you're the boss. They claim, oh, we fell in your house, this happened, or you did this or that. Now we want to sue you.
I hear you. And this is such a great question. And I think this is a question on everybody's mind. I don't know who, Jason or Tony, who wants to take this question, making sure that everybody understands that you have to have workers' comp. They have to provide workers' comp in co-employer or sole employer. So Tony, do you want to talk about that, the concern of being sued?
Yeah, so yeah, we got to drill down exactly the example of the lawsuit that you're explaining, because obviously getting hurt and employees getting hurt and trying to sue for getting hurt, workers' comp covers a lot of that already. But if you're talking about more of the liability of, sexual harassment, discrimination, those kind of things that it definitely can happen. The protection that I would guide everybody to is insurance, is liability insurance. So it's something that I would want everybody to consider when they're looking at the type of employees that they're hiring, right? So like Christiana said, if you're hiring your next door neighbor who you've known, since a baby in diapers, that's an employee that you probably feel safe about. You're probably not even getting a background check, those kind of things. If you're going to Craigslist and Indeed and hiring people just after an interview and you don't know obviously much about them, then, professional liability insurance is something that you may consider. There is a specific type of insurance, and maybe Jason, you might know the name, employer professional.
Employment practices liability insurance.
There you go. So that I think is specifically meant for employers to protect themselves against getting those type of lawsuits. So I'm not exactly sure of the cost and what that entails, but that is the option that I would probably point people to, depending on the type of employees that they're looking to hire.
Jason, do you want to add anything to that?
Yeah, just a little. I would say the same thing as Tony. People can always purchase that additional insurance if they want. And again, it depends on the type of situation. And I will say nothing about changing our relationship to sole employer would stop someone from also suing Mains'l as the FMS too. They might not win because we're not the employer of record, but we also are a large business. And certainly if someone was in the situation that Jordan explained, we have more money than usually an individual. And so we might be the one sued too. We'd still have to defend ourselves. There's still the cost of lawsuits. Our liability is probably less in that case because we're not the employer. But we also still do have some liability. For instance, if it was a question about, you didn't pay an employee on time. Well, if it's because of something you did as the employer, that's different. But if we because we've agreed to be our FMS, didn't pay an employee because we just didn't do it or whatever that reason is, we're responsible for that because you've entered into an agreement with us to do that on your behalf. So that's still a responsibility of ours as your FMS provider. So it really depends on the situation in a lot of those cases. But there's nothing to stop anyone, I would say, from suing anyone else. Their success would be totally dependent on the situation. And that's why there are insurances to protect businesses or employers in this case.
Christiana, can I just jump in? Hi, everybody. So I would say that you could look at potential legal issues in 3 buckets. The first one is sort of physical injuries. And those are all covered, as Tony had said, in your workers' comp. The workers' comp that every employee is required to have in the state of California, regardless of anything. In some FMSs, you can purchase that workers' comp on your own through, let's say, your homeowner's insurance, or you can purchase it through your FMS. Many FMSs are requiring you to use their workers' compensation insurance. So that's the first bucket. The second bucket is sort of the labor law violations that Jason was just talking about. The employee does not get paid in a timely way, or let's say you terminate the employee, they have to be paid within a certain amount of days, and that didn't happen. Those are labor law violations. So folks should know that in this legislation that DVU is co-sponsoring, we spell out in the legislation that says that if a staff member, that FMSs in the sole employer model are responsible for any labor law violations or fines if they are at fault in not paying an employee. So, but there are circumstances in which an employee doesn't get paid because of another reason. For example, you have to approve. So somebody puts their hours in as a staff member, and you as an individual or family member need to approve those hours. If you never approve those hours and the FMS never even found out about it, that's a problem. I'm not saying that you would be required to pay the labor law violations, but these are the things that you need to make sure that you put on your calendar every 2 weeks or whatever the dates are at your FMS, that you are approving the hours so your employees get paid on time. The third bucket are sort of the larger liability issues that Christiana was talking about. For example, let's say a staff member is claiming there was race discrimination, that you in the household in some way did something or said something racist or had wrongful termination of them. This is the more employer liability insurance that we're talking about. However, many FMSs have that insurance anyway because they have their own employees, regardless of the FMS. I mean, regardless of providing FMS services, and they have that insurance, and often we're under that umbrella policy. So I just want folks to remember to not be scared away from the sole employer model. It is the model in the nation of what is considered the standard in self-determination. It is in many states, it is the only model that is offered to individuals. And so it's not like we're reinventing the wheel. Like, this is happening. There are hundreds of thousands of people in self-determination programs around the country who are dealing with all of these issues. And so I don't want you to be scared off from sole employer. To me, it is the only way to have full choice and control over who you hire and who supports you.
Thanks, Judy. That really helped explaining those, the 3 pieces to think about. David M at 503 asked, who was the employer of record in bill payer model? Where does the liability rest? And I thought that was a great question, because remember, in the bill payer model, you are not hiring employees. So there is no employer of record. You're hiring organizations that hire people. Those organizations are the employer of record. You're hiring somebody who's hiring other employers. So there is no employer of record in the self-determination program for the bill payer model. So I hope that answered that question. Harvey, it's always so wonderful to see you. Would you like to unmute?
Yeah, if I could see.
Yeah, I did it.
Okay,
And his Vanna White.
right.
Thanks, Vanna.
I love what Judy said there. I did a little homework today. I did co-chair with Rick Wood and Jim Knight, the FMS committee in Sacramento. Few things to kind of bring into this is cost. If you have a large budget, the employer's burden is a lot of money. And I know we set out there in sole employment. I wouldn't even consider personally co-employment. I never did. Uh, that the customer is the one that purchases the home workman's comp and liability insurance. I'm ex-military. I get, I assure you, I get a lot better deal because a lot of vets have home care for lots of reasons. And I don't know why some FMSs include it in their employer's burden when it should be backed out if if the customer's paying for it. And what I did check with USAA is your liability insurance. For example, if your loved one, your child, is staying in a rental unit or you have a home for them and not at home, uh, the employer of record I prefer is my son. Okay. Why? He really has nothing. He is severe. I know that. And it is a diversion. That's what I say. You know, you got to bring the disabled person into the picture in a lawsuit. And maybe a lawyer may have a little heart. Okay. I doubt it. Okay. And say, I don't want to sue a handicapped person. Okay. And your liability insurance, if they're living away from you, I am concerned about my responsibility as a parent. Sean is with a limited conservatorship, which is health things, financial things. And so there's a little guard on that, not a full conservatorship. And it would be hard, what USA said, to come after me. I don't live with him. I live now, I'm 87 in a senior setting. Okay. And that in itself is a little protection for me. Okay. If someone else, a sibling, is living with your kid in sole employment and they have liability insurance, that liability insurance with USAA to their limit of what they have will protect if they're going after the customer, you know, with the disability. So what people have to do is make sure their insurance, because they're all different, okay, it covers these things. If it doesn't, you got a problem.
Harvey, I think that is the best advice, is that, you know, every person's situation is going to be individualized. So it is important, if you own a home, that you talk to your insurance broker who manages your insurance. Are we covered? Are we not? Do we have enough coverage? If you are a renter, it's not a bad idea to look into renter's insurance. This is to make sure that you have adequate coverage. So, you know, talk to them, explain the whole, you know, the whole scenario, what's going on, and make sure that you are covered. You know, we don't want to tell anybody how much or what they should get, because you need to talk to those experts and your individual case. So that is a really important piece. I'll tell you, insurance is not my favorite thing. I fall asleep anybody tries to talk to me about it. But again, it's a 5-minute call. You call them, explain your situation. They can tell you whether you have enough coverage or not. I will tell you, I called because I was where I'm talking about this today. I called my homeowner's insurance. It was State Farm, and said, if I was interested in getting the employment practices liability insurance, what would it cost me? And so she looked it up. She said, based on it has a few questions that they're going to base it on. And for us, it was part-time employees, how many hours, those kind of things. And the quote she gave me was $60 a year. So we're not talking a huge, at least in my case, and now I can't guarantee that that's the case with everybody's insurance. That was just the one that we talked to. So check into it. You know, that part of we love self-determination for the freedom, but we can't forget that in that freedom, we also have responsibility. And so, you know, it is an important piece to check in on those things. We had a question from Deborah Jurgensen at 509. And it was for Jason. And she said, could we try to align changes to the spending plan with annual transition dates for those that fall within the next few months? And that way we don't have to revisit the spending plan multiple times, which makes more work for everybody.
Yeah, it's a good question. And we considered doing this over the process and doing the change when people's spending plans start over. But that would lengthen out a process that's already going to be a little longer for us because it would take a whole year to get through everybody. And because we don't expect that people will really have to change their spending plan, we're hoping that that won't be a problem. People could choose to change their spending plan at the same time if they need to, or if you know they will have a very small amount of savings in the employer burden that they could use for something else. But in general, we're hoping that people won't have to change their spending plan, so it won't be a lot of work for people.
We're actually getting lots of spending plan changes questions. And so, hold on, I want to see if I can gather them together. Oh, I thought this is an interesting one. So because that we're Teresa at 509 said, since we have to make these spending plan changes, and they are using facilitators, are they going to get an increased amount to accommodate for the cost of the facilitators? And I would say you will not get an automatic amount, but I will say changing if this is really going to cause a hardship for you and it is a change in circumstance, call an IPP meeting, talk to your service coordinator, let them know what's going on. You know, I can't guarantee anything, but it's have that conversation with them. You know, that it's important to let them know that it's going to impact you. Julie, would you like to unmute?
Hi, hopefully you can hear me. I have a quick question because I'm at the same thing. We're switching right now. My budget's due on September 1 and we're just switching anyways. So hopefully it falls within an alignment for Mains'l. But my big thing is just like the gentleman was talking about earlier, I'm really prone to do an EIN number for my daughter, not for me to protect myself because we have a conservatorship, a limited conservatorship. We have a trust fund, that's a non-funded trust fund for her, special needs trust fund. And how I'm perceiving it is, to me, that EIN number should be in her. She's an adult, she's just 21, but it's her plan, it's her self-determination, it's her budget. You know what I mean? So, and also to protect myself, because I live in California and you can't look twice without getting sued somehow, you know what I mean? So for protection of our property and her special needs trust. And so I went to my lawyer and he said, no, definitely, for me, definitely put it in her name because she really has no assets and the special needs trust is not accessible to her because we have a fiduciary for that. So I just wanted to ask the people on the other end, Mains'l and Seqouia, is that your understanding? I know every situation is different, but I know.
Yeah, you're exactly right. I mean, yes, every situation is different, and I wouldn't tell you specifically what to do, but it sounds like you're on the right track. And yes, if I would have your child be the employer. And the other consideration is, I don't remember your case specifically, Julie, even though I've seen your name on our stuff. If you are an employee working for your adult child, you can't also be the employer in this scenario. Like you can't be self-employed in the self-determination program. So that's just another consideration. If you're an adult who's getting paid as an employee, you can't also be the employer of your of your adult child. So that's another good reason that you want them to be the employer and have that EIN in their name.
Something else I would add, thank you, Jason. I'd say the exact same thing. Well, as we've been talking about, sole employer being the nationwide way that FMS works, in many states, they require the participant to be the employer. So the typical traditional FMS way is for the participant, no matter if it's a baby or an adult, to always be the employer. So that's something else to consider too.
That's great to know. We learn something new every time we come here. I love it. It's the best part of my job. So Lori Bardis at 520 said, and this is a great question. We were actually discussing this today. So where is the insurance money or payments coming from? The budget, is there a code for that? And the family should not have to pay. We were actually discussing this today with DDS of what service code does the insurance go under on the spending plan? And we don't have a definitive answer, but as I've been doing it along the way as an independent facilitator, what they have seen, what they've approved was whatever code that employee is working under. So if they're under 320, you would see their hourly rate, then you would see their employer burden, and then you would see their insurance, if that's where it would go. Jason, have you seen about the same?
Yeah, I was hoping you were going to give a definitive answer because I've seen it in multiple places, but what you're saying makes sense. Yeah.
That they keep it together. And no, families should not be paying this. This would be coming out of your spending plan. So families do not, you wouldn't be paying for this. But then the other piece was, will the budgets be increased for this? It's like, no, this is part of, so when you think about the budget is based on what you would be spent on you in the traditional system. And so what might be spent on you, let's say, might be like a respite agency, and the regional center pays this respite agency, do not quote me this number, $58 an hour, but they're paying the person who actually comes out to your house minimum wage. And they are the rest of that is for their costs, their administrative fees, or whatever. Now, when we go into self-determination, we can take that whole $50 an hour and say, well, I'm going to pay somebody $30 an hour or $28 an hour, which is more than the minimum wage they're making, and I still have leftover money. And that leftover money helps pay for these other things, your employer burden, your insurances, those kind of things. Or however you spend it may be I'm using less respite and I'm going to be taking classes instead during that time. So that's kind of how that original budget gets moved into the spending plan. It's not dollar for dollars. It's just a total amount and you get to spend it how you want. But that means you do have to plan for these things. So there are some things that are kind of, you got to pay for them in your spending plan. You got to think about, that's like that health insurance piece we're talking about. You have to realize what things you have to pay for in there. Kathy, how are you doing? Go ahead.
Is that me?
That's you.
Yes, I had a couple of questions, but my main question, and I've heard different answers, is if a staff member is driving their own car and they have the client in the car and they get in an accident, can you discuss liability and how either the employee or the employer or the FMS is supposed to cover that liability?
Do you guys want to take that? I can start by saying that your auto insurance covers you when you're in your auto. And so it wouldn't be workers' comp. It wouldn't be those pieces. It would be your auto. Tony, do you want to jump in?
That's exactly what I was going to say. And something that we do when we're looking at new participants and spending plans and kind of reviewing things is that if we see mileage and transportation in your spending plan, we automatically require auto insurance from your employees who are going to be driving. And that's, again, is just a way to protect you guys and making sure you guys are successful in the program, and you know, getting an accident without auto insurance and going through that process would not be fun. So that is exactly what we would do with auto insurance. Yeah.
And do you require them to get, because they're driving, if they get in an accident, the accident's occurring while they're quote unquote on the job? So do they have to get an amendment to their auto insurance that covers them in that case?
I don't know.
Yeah, that's something I would suggest people need to talk to their insurance company to make sure that they're covered if they're using their vehicle for work purposes. Normally when you like get a policy, they ask if you're driving for work or how many miles you drive or things like that. So it might be good to ask that question. Just like Christiana said, it's good to ask.
But it would definitely be on the staff's responsibility to make sure their own insurance covers them. The FMS would not cover them, correct?
That's correct. Yeah.
Correct.
So, and I was told the same thing, that if they are driving their own car, their insurance, they need to let their insurance company know that they are driving for work, and then they would be covered. If they're driving the participant's car or my car, then it would be under my auto insurance, and then I would need to get insurance to cover them driving my car. So those are the two pieces. It gets confusing because, again, like, how many freaking insurances do we need to have? Apparently a lot, and different ones cover different things. So
Christiana, I want to add something on the car insurance. And every auto insurance is different, but you should know, always remember, the self-determination program is not in a vacuum. Lots of people have babysitters of neurotypical children who get driven to parties on the weekends when mom and dad are out of town. Okay, so are those parents getting special riders on their insurance? No, it's not necessary. If the person is being driven in the car that they own, then you don't have to do anything special. If the employee is driving for work, they really should be responsible for calling their car insurance company and letting them know this is what they're doing. There may, in fact, be an added cost, and you could figure out how to compensate them for the added cost. But that should also come in if you're paying for their mileage. That mileage shouldn't just be like how much per gallon they're paying. It should be other costs related to the wear and tear of the car, the insurance for the car. So all of this should be compensated to the employee in alternative means. Do not feel like you are running out and buying auto insurance for somebody special. The stuff is taken care of.
Ada Scott at 526 asked, are you saying the co-employer model is going away in California for all FMSs? We are not saying co-employer is going away in California for all FMSs. There was a rumor that I've heard from tons of people that GT was getting rid of their co-employer model. I called them, I talked to them. They said they have not heard anything about that from their home office. That is, so it's just a rumor at this point. And so no, that does not mean that it will completely go away in California. Shannon, go ahead.
You guys hear me?
We can.
Can you hear me?
We can, go ahead.
My son uses a separate company for his caregiver called A+ Home Care, and I believe they have all the insurance. So is there a big change other than paperwork?
So I think I missed the part. You're hiring somebody who is already working for
Through
you?
an agency.
I hire through A+ Home Care, an agency.
So they carry all their own insurance, Shannon.
Yeah, so nothing should change. Okay, that's what I thought. Because I talked to Joe this morning. He's like, nothing should change I know of other than signing paperwork that we're changing your training services.
Right. Remember, we're just talking about when you are hiring people directly. If you are using an agency, they have all the requirements, the liability insurance and all that kind of stuff.
Yeah, that's what I have. Okay, I just want to make sure that's what I have. Yeah. Thank you.
Oh, I've got a good one I don't know the answer to. Tiffany Vacaria at 536 asked, what if a client is fully conserved? Can they get an EIN?
Yes.
Yes, they can.
There you go.
A baby can get
Yeah.
EIN. A
Anyone.
dog can get an EIN. I'm not kidding.
I will have my dog get one.
No, that's not true. You do have to have a social security
Yeah.
number. So a
You
dog
do.
cannot.
Your dog really can't.
Oh, dang it. Okay. I'm claiming discrimination for my dog. Beth, go ahead.
Hi there. Thank you to everybody for this. This was so timely with so many people having to switch. So much appreciate that. I would like to beg Tony to adopt Mains'l's policy of not requiring a spending plan update. I'm more than happy to sacrifice the incremental burden gain that you will get to not have to run 2 spending plans through Regional Center of Orange County in the next 2 months. The amount of time and labor for that, I mean, it's just giving me a heart attack. So I would just beg you, Tony, since Mains'l can do it that way, that you would take that back to your company and consider that.
It's definitely something worth considering. Actually, I was thinking of connecting with Jason after this, if you can, and just discussing how you guys are actually not requiring edits to the spending plan, because I was told by the regional centers that they, in their system, like we know, the regional centers split up all your money into different categories in their, authorization system and their management system. And so what I was told is that they have to move that money from co-employer to sole employer because it's 2 completely separate models, 2 completely separate, divisions of services. So if that's not the case, if they can just keep all that money together, then maybe I was told different. So I can definitely follow up and figure that out.
I might have an answer why the difference, and I could totally be wrong. I'm just throwing this out there. Mains'l has one vendor ID for all 3, co, sole, and bill payer model, whereas most of the other FMSs have different vendor IDs for each of the models. So I think that might have an impact on it. Jason, jump in and tell me I'm wrong.
Well, I actually didn't know that the other FMSs have different provider numbers for it, but that could definitely be part of it. And I think different regional centers also do it a little differently too, where they want to move that money. But we've, rather than revising the spending plan, if they need that, we can give them the total of what was spent up through a certain date, and then they move the rest to the next one if they need that. And we wouldn't be able to do that till after kind of the date of the switch, because we don't know how much has been used until we've paid employees and such. But I'm definitely willing to talk to you about it, Tony, and make sure we're also not forgetting anything. We're really trying to make the process easy, as painless as possible. And we know we don't want to make people change their spending plans if they don't have to. And just on top of that, hopefully in the future, it won't be such a big mess to change a spending plan if that needs to happen.
Jason, that is what we want so bad. We are all working towards that.
Yeah.
Christiana, can I have you call in Makai, our great friend Makai, next?
Absolutely. Makai, go ahead.
Good afternoon. I have a son and he'll be leaving for college. Hopefully next year. We just got through advocacy into our self-directed program. My question is, how easy is it for someone to, I'm thinking for us at first to go into a direct care model just to get our feet wet, and then once he leaves, if you think he'll be leaving to go to college somewhere in Southern California, to go into a self-directed plan. How is it to do that? And have you had experiences of steering? We personally had the experience of counselors wanting to steer me away from self-determination. So what should we be aware of when we say, oh, I want to start with one plan versus another? Thank you.
Unfortunately, I'll tell you that you're not the first person that has told us that service coordinators have steered them away from self-determination program. I think some of it is that, you know, we have so many service coordinators, and so a lot of them don't have any experience with it. And so there is kind of a fear of it. We don't know what it is. It is on our radar about getting service coordinators trained and making sure that doesn't happen. For your question about your daughter going to college, as long as they're staying within California, they can stay in the self-determination program, continue their services while they're in college. And, you know, as long as their home is still your home, you don't have to worry about changing regional centers or anything. That's fine. It becomes an issue if they leave the state. They wouldn't be able to use their self-determination program money while they are out of state. But it wouldn't go away. They could use it when they come home during vacations or those kind of things, but they can't, you can't use that money while they are out of state. So I hope that
they would be in California, don't they?
Yeah.
They have whole different needs when they're, you know, in college, housing, all that stuff. And
Yeah, so sorry.
No,
Mikhail, I think the self-determination program is perfect for college students because it gives you the flexibility and control to hire people to support you in a dorm room or to support you to take notes in a class. There's kind of no restrictions for you. And I know a lot of people in college who are in the self-determination program. So I strongly recommend it.
Thank you.
Thanks, Mikhail.
So we had a question from Deborah Adler at 5:32. Can the spending plan for the employment practices insurance, if so, will a new spending plan need to change to authorize the payment? So I need you to know that the employment practices liability insurance has just kind of come on the radar of DDS. What they did tell us was that for the directive for the employer burden for the FMSs, that they are not preventing them from including that with the workers' comp liability, employment practices liability. So they're saying that is fine for them. For us, so if you're a sole employer, you're gonna say, I want to get it. We're going to say that you should be able to purchase it, but that doesn't mean it's not going to take a while for the regional centers to catch up. That it may be a bit of a battle, and we're going to have to do some pushing. But we are not hearing any reason why it couldn't be included, and that you put it in your spending plan. So we're on the cutting edge here now of how it's going to be put in your spending plans, what it's going to look like. But yes, as far as we know, that is what's coming. So, Franca.
Hello.
Hello.
Oh, hi. Sorry, I had a quick question. Because we're just new to the self-determination. So I had actually maybe two questions. The first one is, how do you deal with, like, I guess, problem employees? Like, especially this is very new for me, getting an employee for my son. Especially when you have an employee that constantly calls off, and it seems like they just want to use the um, sick hours that was immediately assigned to them. We've been into it for like 3 months now, and this specific employee has been calling off every week, and most especially once they saw they had the 40 hours assigned on their pay stub, they've been calling and trying to use all the sick hours. So, and then the most recent one was recently they just called in for the last shift again, saying that they got into an accident on the way to work. So it looks like they probably want to use the rest of the sick hours that they have.
Unfortunately, there's nothing that prevents people from taking advantage of the sick pay. But I would say, remember, you are the employer. And if this person is flaky and they're not showing up and those kind of things, that you can let them go. Make sure to talk to your financial management service because they have to have their check. Tony or Jason, what is it within 24 hours? It was a short period of time. I can never remember when you let somebody go. They have to have their check ready for them.
Okay.
Pretty sure
And
24 hours, yeah.
Mhm.
Okay, I see. And so pretty much as an employer, can a employee say they want to use up all their sick hours within the first month, or is there any policies that you can have in place to let them know, okay, they have to work specific amounts of weeks first before they're entitled to it, or pretty much they are just entitled to the 40 hours as soon as they start working?
This is a great question, and I do not have the answer for you. And I'll tell you why. We do know that employers can choose whether to have them up front or earn, like some places have you like for every hour, you get an hour of sick leave for every 30 hours you work. And I don't really have an answer in sole employer if you can choose that, or my guess is it's really going to be the financial management service because you're going to look at their pay stub and you're going to see either they have the 40 hours available or they're earning them as they go. So Jason or Tony,
Yeah. That's exactly right. It would depend on how your FMS probably has their payroll set up or how they're set up to accrue, whether they're going to accrue that sick time over time or get it as a lump sum right away. At Mains'l, we do it right away, and we if you choose us as your FMS, we don't give you the option to pick one way or the other because we have to manage that for all the employers differently. But once the employees have it, they are eligible to use it. So, and you can't really say no, you can't use it today if that's their choice.
Yeah, so for Sequoia, we do it a little differently. We kind of do it to protect kind of this situation with employees getting it right away and then using it quickly. So we do follow the typical guidelines of every hour, you get 1 hour for every 30 hours worked, but it does not become available until 90 days. And then once 90 days hits, then you can start using what you've accrued.
so we learned another new thing today, which is ask your FMS how your employees will get their sick leave pay. And MH at 522 said, in SDP, does the sole employer have to use check-in, check times on apps like regional centers to require service providers coming to our home? What I believe they're asking is in sole employer, do they need to use EVV?
For us, we require EVV for every employee. Yeah.
Everyone.
Yeah. And
It's-
it won't, there's no difference for us to either. If they were, you have to use it in co-employer, you also have to use it in sole employer. Yeah, there won't be a difference.
It's a requirement for all direct support professionals in the entire country.
So you don't get out of that.
No.
We are out of time. Kathy, I'm so sorry. I want to thank both Tony and Jason. Thank you so much for being here. We really appreciate you coming. I want to thank our interpreters who always work so hard because I know I talk fast. And we will see everybody at Connect. Our next Connect, we're going to be talking about ABLE accounts. So we will look forward to seeing you at our next Connect.